or a change in terms of conditions of release.
All right.
Not that I'm saying that is a defense that we should just overlook. Not at all.
Okay, I understand your point. Let me let you go on and develop your argument. I'll try not to interrupt it.
No, you're fine, sir.
Okay.
I appreciate it if you
All
do.
right.
You direct me to where I need to be.
Okay, go ahead.
I do want to say that in this particular case, and this is hard, I think, for any lawyer to do, but I want to do it at this time. When I came into this case in March, I just tell you, Your Honor, and I should have, and it's my fault. I did not envision, I just did not envision somehow that an incident would take place where, in my client's mind, an emergency was needed to where he would need to go to Canada. I just didn't envision it. I just didn't have it. I look out every day from the office and I see Canada over there, and it's, you know, a good 2-iron for Tiger Woods to hit it from over there, and I just didn't see that would be needed, and nor did I address the court with that. So what I want to say to you today is I believe in my heart that part of this is my fault for not seeing that and not recognizing, because I just look at that land and I just see it, there it is, and it's less than 1/8 of a mile, and as somebody put yesterday, it's closer to go over there than it is for him to go to the house.
Mr. Parkman, I guess in some ways we want to, you know, sort of recognize, you know, that your client is not, you know, what you might call the typical defendant here.
Yes.
But being atypical also makes an exception in this case, because we have a person who's a member of the State Bar of Michigan, the mayor of a city, a person who has served, you know, in government, someone who should know and respect, you know, what is required by court order and court procedure. You don't have to nursemaid him or carry him by the hand or stand around him all day and night in order to decide what he should or should not do. So, I mean, I can understand you saying, you know, it's your fault, but if we don't, you know, I have clients, but defendants who come here who have mental problems and so forth. Maybe in those cases it's necessary for the lawyers to do certain things. But I think that is not a very good presentation or logical reason to excuse not following court order because you didn't tell him. Move on, please.
All right. Again, let me say that it's not an excuse I'm giving. It's, again, mitigation, Your Honor. And that's why I believe that in this particular case.
All right. I'm sorry. I said I wasn't going to interrupt. Let me see if I can hold to that. Go ahead.
Okay. So, thank you, sir. Finally, in getting down with this, I think, too, that the court ought to give credence to pretrial services because, you know, they're in the case, they're aware of the case, they understand the case. And this,
I hate to interrupt. I don't get the pretrial service until we decide the issue of whether or not there was an abuse of discretion. Okay. Pretrial service only come into play as to what their recommendation may be as to any bond conditional modification, what I should do with that. And if we get to that, then I'll let you make that argument. Okay?
Thank you.
All right.
Just so you'll understand, my understanding was that was prepared before the hearing yesterday, and I just wanted the court to understand that I felt like, again, that could be an element of abuse of discretion.
I see.
So please forgive me.
Okay, I respect that, man. Go ahead. I'm sorry.
No, sir. That's okay, sir. Thank you very much, Your Honor. So finally, Your Honor, what I want to say to the court is that in this particular case, I do not believe in my heart that Mayor Kilpatrick just totally ignored the court at all and just said to heck with it and just walked away. Now, in all the cases that we've had and what's happened in this case, is he has been required to do some things and has been given some leniency in other things. The requirements that are different that I understand, and I haven't practiced here in Michigan, but in talking with other lawyers that do practice here, is he was required to show up every day on every hearing, no matter what it might have been. He was required to be there. And other cases, my understanding is some judges don't require that. On each occasion that Mayor Kilpatrick was asked to be there, not only was he present, but he was on time. And so I think that is a key factor in this, because what we're looking at what we're really looking at on release is the following. Is he a danger to society? Is he a flight risk? I mean, that's what it boils down to. So if you take a look at the record in this case, let me show you this if I can. If he's been there every moment, if he's been there every time, on time, that to me shows respect to a court. I know because my Johnny Six-Pack, he wouldn't show up until a week later when I had court. But he's been there, and he's been there. Let me show you something else that I think is important. when this issue came up, and I learned about it through the news, we went to see Judge Giles, and I don't hold my to the date, but it was like last Tuesday or something. We went over to the courtroom with the prosecutor, Mr. Moran. I think what's important in that is the judge knew, and we told him that he was out of town. I won't go into that right now, but he was out of town with permission from the court and return.
Okay.
I think the important part about this is this. Judge Giles at that time didn't say, I have a concern about him being a danger, or I have a concern about him not coming back, so therefore we'll continue the hearing for your request. That was our request. We'll put it off until yesterday, on Thursday. So a week or better passed. Nothing was done during that time period. I would take it from that Judge Giles is saying, and I'm not trying to read anything into his mind, but I would certainly think that he is saying, I believe he's coming back. I don't believe he's a danger to anybody, and I don't believe he's a flight risk, or else he would have issued a warrant at that time to pick him up. So I think going back and looking at the law in this case, that while Judge Giles made reference to some things that he did and how it made Judge Giles feel, I still believe the law is very clear in those cases that I cited that in this particular case that he's entitled to a reasonable bond and that he is not a flight risk or a danger to the community. Now, with that in mind, finally, I want to add this. The prosecutor was asked yesterday, and I'm not trying to put words in their mouth. You've got the transcript, so don't hold me to the exact words, please. But the prosecutor conceded yesterday that even in light of what took place, they didn't necessarily move for the revocation. They moved for a change of conditions. Now, I would submit to the court that who would better know this case than the prosecutor, who would better know this case than the defense, and with that in mind, I believe that once a recommendation is made by a party, it should be considered, and I don't believe that it was. And I believe that also is abuse of discretion. So with that, Your Honor, I would say that we would ask, please, for this court to reinstate the bond. I think this court can do that. I believe the court can do whatever it deems proper and necessary with any changes or conditions of release that you can attach to that bond reinstatement. And we ask the court to please consider these arguments. If there are any questions, I'll be glad to answer.
I'll thank you for your comments. I'll give you a chance to respond and hear from the prosecution.
Your Honor, thank you for your time.
Okay, thank you.
This court knows the law much better than I do when it relates to the concept of what an abuse of discretion is. And the court's familiar with the cases, but to me, my understanding of the law of an abuse of discretion requires a showing that there is a perversity of will and logic, that the decision is made from passion, bias, prejudice, not logic, not common sense. And that's the definition in Michigan of what an abuse of discretion is, which the court was required to find to modify the bond set by Judge Giles. I find it interesting that counsel for the defendant says that Judge Giles abused the discretion yesterday in making his decision to remand the defendant on the one hand, and yet he contradicts himself because he says that on the 28th of July, when Judge Giles was informed about the violation of bond on the 23rd by going to Canada without prior approval from the court, Judge Giles did not issue a bench warrant, did not require the defendant to immediately return from Florida to face him in court. He said, I'll deal with it when he returns. It shows a deliberative process that the judge went through and said, didn't fly off the handle, didn't have a passive response, didn't have a response based on passion, but a response based on reason, and said, fine, he's out of town, I'll deal with it when he gets back. That is the very definition of discretion. Now, counsel wishes to paint this whole episode that took place yesterday in court as a one-episode deal where the defendant was punished because he went to Canada and didn't tell anyone. And that's not what transpired. What transpired was a series of events